Welcome to the Legacy Cast by Kelley Legacy Law.
Hello and welcome to the Legacy Cast by Kelley Legacy Law with founder Michael W. Kelley. Their practice focuses on helping families enhance their lives today and secure their futures tomorrow. I am your host, Kevin Rosenquist, and today we're going to talk about shielding your legacy, why asset protection matters for your children's future. Michael, good to see you.
Hey, thanks for having me back.
Absolutely. All right. Well, talked some about kids last time. We're going to keep that going. Why is asset protection an essential part of estate planning, especially when passing wealth to children?
Yeah, a lot of people don't realize that they can give asset protection to their children. A lot of people that come to me, especially when we're talking about trust planning, think that, that they can create a living trust and put their assets in it, and then it'll be protected from their creditors, which I have to set them straight. Hey, think about it. If we could all do that and just put our assets in a trust, we could run amok on society and cause all kind of havoc and then say, hey, our money's safe over here in this revocable trust. So when we talk about asset protection, when we're talking in a revocable trust scenario, we're really talking about being able to give it to our children. So, a lot of people don't really think about what kind of hazards are out there when they're doing estate planning, specifically if they're thinking about, okay, I've got a last will and testament, everything's going to my kids, so I've done what I need to do, right? Well, when you leave something outright to someone, meaning as soon as you die, they're going to receive it, they're taking it subject to everything that's going on in their life. So maybe you've got a situation where a 19-year-old will be coming into $1 million and, they're not ready to handle that. They're immature. They may skip college that you want them to go to and go live in Europe for a decade until the money's gone. And then all of a sudden they have no education and they have no money left. So that's one reason, immaturity. Potential divorce is another reason. You may want to protect the assets for your children so that if they end up with an ex-spouse after they've received their inheritance, that ex-spouse doesn't end up with half of that. And then judgment creditors, even if it's just something unfortunate that happens, maybe it's a car accident where they're at fault or something like that. And there's a judgment out there. All of a sudden, if they come into some money, then that judgment creditor is going to be able to seize on that. So, that's why it's important to be thinking about, that. Plus, what if we have a child that's in one of the professions? What if they're a doctor or an attorney or something like that where they've got a lot of potential liability? Do we want their inheritance to come to them and be subject to that potential liability? Or do we want to leave it in some kind of trust for them where it can be protected in that scenario? So those are some of the reasons why we need to be thinking about asset protection when it comes to our kids.
What are some of the biggest mistakes that you've seen parents make when transferring assets to their children that you might want people to know about on this podcast?
Well, number one is trying to avoid probate by transferring real estate directly to them. Okay, so
that's right. We talked about that a little bit last episode. Yeah.
Yeah. And that's a big one. I mean, that real estate is the biggest investment that most people have. It's their biggest asset, and they want to do the right thing and try to make things easy for their family. So they may just go ahead and deed this over to their child, not knowing that they're going to be causing a capital gains tax burden for their child at some point in the future. So that's one big mistake. Another big mistake is, like I said, just leaving things outright. If you've got potential liability, leaving things that way without any other advanced planning. A lot of people like to do what I call reaching out from the grave to control assets. So they'll say, okay, in my last will and testament, I want my spouse to receive this second home of ours. And then when she's done with it, she has to leave it to my children from the first marriage. Well, unfortunately, when you leave something outright to someone, it's theirs. So that former spouse, that surviving spouse receives it, they can go get remarried, and that asset is gone forever. They can redo their estate plan and leave it to their new spouse or to other children that they may have. So those are some of the mistakes. You can accidentally disinherit your own children in that scenario, leaving everything to a surviving spouse, and then just trusting that they're going to follow the wishes you had set out previously.
Yeah, we like to just assume we trust people, especially the people we're closest to, but doesn't know. It's good to have it all laid out the way you want it to avoid that.
And I've seen it, conversations I've had with couples, blended families, and all the kids, even though my stepchildren, we've been together 25 years. We're all one family. I consider his kids to be mine and vice versa. Everybody's going to get everything equally. And then as soon as one person dies, surviving spouse does something that nobody saw coming, against one of the children from the other, one of the stepchildren or something like that. And it's just, it comes at you out of the blue because it's like, this is not the same person that we met with when we did this plan.
Right.
when both spouses were here. So when that void happens, you never really truly know what somebody might do.
What are some of the pros and cons of giving assets to children outright versus using a trust for protection? You touched on it before, but can you elaborate a little bit more on that?
When you think about it, a lot of people want to make sure that when they leave something to their children, that it's going to be for the benefit of their children, right? And so the question is, if we leave something outright, what is our ability to control that? Or are there other ways we can leave it? So you may see, for example, people, if they're doing a trust, will leave things to their children in what I call an ages and stages distribution. So, hey, I'd like for these assets to be held in trust for my child until they are 25 years old. We'll name a trustee that can manage, invest, and spend this money for their health, education, maintenance, and support until they turn 25. And then when they turn 25, they have the right to withdraw a third of the money that's in the trust and take that out and spend it however they want to. But the rest of it's going to stay in trust until they're 30, when they'll have the ability to withdraw half of what's left. At age 35, they can get the rest. So that's a way for people to spread out the distributions and spread out the risk of divorces and creditors and things like that. The other way that we can leave it is called a lifetime asset protection trust. There are different names for these things. This is what I call them. But a lifetime asset protection trust is exactly what it sounds like. We can leave assets in a trust for our child's entire life. We name a trustee that's in charge of it. And again, it's to be used for their benefit. If it's an independent trustee, we might give them total discretion on how to spend it. If it's an interested trustee, which means a family member, then we might say use it for our child's health, education, maintenance, and support, like we talked about earlier. But this is a way not only to protect the assets for our child, but also to create sort of a dynasty trust, if anybody's ever heard of that, where, some states you can basically create a trust that never ends. That's perpetual, generation after generation, as long as there's money in it. Now, in my state, we don't have dynasty trust. I think Nevada has those. But, you can at least go a couple of generations down the line before something that's called the rule of perpetuities kicks in, which I don't know a lawyer or law student that understands how that rule works. But it's like 21 years after the last person's life that's measurable dies, then the trust has to end. Okay. But those are ways that we can protect them. Now, here's another cool thing, though, about a lifetime asset protection trust that you can do for your children. There's two things, really. Number one, you can actually name them as trustee of their own trust share so that they do have control over the assets. All right. They don't have to go ask permission from some third party. Now, when you do that, they lose a little asset protection because the more control you gain over your trust, the less protection you get. The other thing that you can do that's really cool is give them what's called a power of appointment. So you may say, look, when we set this trust up, we're leaving it in trust for our child. Whatever's left when they die goes to our grandchild or grandchildren, however many kids they have. But you can give your child the ability to make adjustments on where it goes after they're done with it, with something called a power of appointment, where you can say, okay, I'm going to give my child the ability to make adjustments of the percentages between their children on how it goes, or give them the ability to also give some to charity if they want to, or even leave some to their spouse when they die. If they want to leave some to their spouse, they can do that. So there's some flexibility there where even though we're leaving it in trust for our child for their entire lifetime, we can give them as little or as much control as we want them to have and give them the ability to make some changes on where it goes after they die.
Okay. And you mentioned there's a lot of different names for trusts and all that. Are there specific types of trusts that work better for asset protection?
Well, it depends on what your goals are. I mean, we've been talking about revocable living trusts, but there are irrevocable trusts that if you have property that you want to get out of your own name and get some asset protection, you can create an entirely separate trust called an irrevocable trust. You can put property in that irrevocable trust. Now, the caveat is you have to give up control of it. So instead of me continuing to be the trustee over my own trust and in control of my property, I'm essentially saying I'm putting this property in this irrevocable trust over here, naming a different trustee. Now, I may be able to still receive the income that's off of the property that's there, but that's out of my name. It's out of my estate for tax purposes. And therefore, if I do something, then, that property should be insulated and protected from anything that happens with me, because technically I'm giving it away and it's not mine anymore. We have this where you see like a Medicaid asset protection trust, and I'm not an elder law attorney, but, people are always looking for ways to defeat this 5-year look back rule that Medicaid has. And they say, how can we protect our assets for our kids if we have to go to the nursing home? Well, there's a Medicaid asset protection trust, an irrevocable trust. You can put property in as long as you live that 5 years, before you have to go into the nursing home, then it can be protected that way. So there are lots of ways that you can protect assets. There's even offshore trust. There's, you can go to the Bahamas, all these different places in the Caribbean. There are attorneys that just specialize in that kind of stuff. That's not me, but there are attorneys that'll specialize in that kind of stuff.
For your first example, where someone might want to use an irrevocable trust and put their stuff in there, they kind of lose control. But why would someone choose that? What is the situation that they would want that?
Yeah, some people, they have an estate tax problem. They may have to pay inheritance tax on this property if it is, in their trust. And so therefore part of their taxable estate. So right now, the inheritance tax exemption is $14 million per person. So most of us don't have a problem with that, but some people do. Maybe they've got a family farm and they know they want the grandkids to have that. Well, they deed that farm over to this irrevocable trust, and the way it's worded properly will take it out of their estate for tax purposes. So that's one way to get property, out of their names and move it on down the line to the family. They obviously have enough money. They don't need the income off of it, or they don't need to sell it to have the money to live on. So they can pass that property on in an irrevocable trust.
Okay.
And do some of that tax planning.
That makes sense. That's actually a good segue, because my next question was going to be about estate taxes. And, aside from that, what are other strategies families can use to minimize those when they're passing wealth to the next generation?
When we structure revocable trusts, we can do some things there with the split of assets when the first spouse passes away, to structure those things where we can put a certain amount of money away in a sub-trust to protect it from inheritance taxes. And, there's something called portability, where the surviving spouse can actually use any unused portion of the deceased spouse's exemption amount. So essentially, whatever the exemption amount is when the first spouse dies, that's locked in as far as how much exemption they have. So if the law changes later, the surviving spouse, if they ported the unused portion from their deceased spouse, can add on to their current exemption when they die. I know it's getting technical, okay, but that will allow them to protect assets. So when they die, they have the full measure of those exemption amounts to shield the money going down to the kids from inheritance tax.
Got it. Technical, but I understood it. So that was good. You didn't get too technical then. Last
we just scratched the surface on that one, Kevin.
Okay. Yes. Yeah, you did. Okay. Gotcha. Good to know. For parents with young children, what steps should they take now to ensure their assets are managed properly if something happens to them? We touched on this. We talked about this in the last episode, but in the terms of what we're talking about today, what steps should they take?
Yeah. The kids protection plan is huge. Selecting and naming your permanent guardians, not only in your will, but also in a separate document that can be used if you're just incapacitated, naming your temporary guardians, but also choosing, if you do a trust, naming who the trustee is going to be and which assets are going to be held in trust for those kids. When are they going to receive those assets? We talked about the ages and stages. We talked about the potential for the lifetime asset protection trust. So those are the things that people need to be thinking about with minor children. Now, if they decide for some reason, a trust is not right for them, as far as a living trust, you can set up a trust inside of a last will and testament. It's called a testamentary trust. All right. Does not exist until after you die and your assets have gone through that probate court process. Okay. So once you've done that, then your executor can take whatever money is there that you've said, okay, I want a trust to now be created to hold these assets, and I want this person to be trustee and manage those things. So there are different ways to go about it. Some people may say, I don't have a lot of assets now, so a revocable trust may not be the thing for me, but let me put a testamentary trust in this will just in case I die before my children are adults, and at least it can be put aside for them and used according to the terms of that document.
Okay, that makes sense. How long have you been doing this, Michael?
I've been an attorney for 17 years. I've been doing estate planning for, I'd say, about 12 years now.
All in Alabama?
Well, I do have a little experience in Montana just because my first real experience into estates and trust administration was when my uncle passed away. He was originally from Alabama, but he had moved to Montana, and he named me the executor of his will and the trustee of two different trusts he created. He had a revocable trust in Montana, and he had what's called an irrevocable life insurance trust in Alabama. All right, that was a common planning technique people would use when the death tax exemption was really low. All right, so that was a way for people to get money to their kids or grandkids in trust, but around their estate tax. So I'm still the trustee of 6 of those trust shares today. But I had, seasoned attorneys in Montana that were helping me, manage that estate out there, and, seasoned attorneys in Alabama. And both groups said, you have seen more in dealing with this estate out here as far as the different things you might run into to have to deal with than most of us have seen, in our entire careers. So
wow.
I got a real baptism by fire, but I did find out I enjoyed it quite a bit, helping people, put their puzzle together and try to avoid conflict by doing planning on the front end.
How'd your uncle do in setting it up?
The setup was great, but I will just say this without going into too much detail. It's a case study in making sure that you keep things up to date as things change in your life. Because if you don't, then it can cause issues that have to be dealt with by your family later. So setting it up is one thing, but maintaining it is a vitally important thing to do.
Yeah, that's a good way to end our conversation. Even if you got one and you're listening, maintain it. Always maintain it.
Right.
All right. Well, thanks for tuning into the Legacy Cast by Kelley Legacy Law with founder Michael W. Kelley. To connect with Michael and the team, head to kelleylegacylaw.com. Please be sure to like and subscribe to our channel and leave us a review. Michael, thanks so much for your time. Really appreciate you being here.
Fantastic. Thank you so much, Kevin.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.